by enabling parties to pursue out-of-court settlement whenever possible. I will also promote the use of ICT in our processes by actualizing or putting into practice the use of ICT in proceedings and also other processes in court.
Thank you very much. Don't you think we should allow you at least some time to serve at that position and prove yourself in this position before we hand you over to another responsibility?
Thank you, Honorable Chair, for that question. Yes, I would agree. I need time to prove myself in this position. But like I said, I also do not doubt that I have the qualifications and experience necessary to serve as a judge. And that is why I'm here, Honorable Chair.
Thank you. Then let's go to the High Court, and you give me some 5 jurisdictions of the High Courts that are different from the ones you are exercising now as a Chief Magistrate.
The jurisdiction of the High Court
are different.
Which are different. The appellate jurisdiction is different. The High Court appellate jurisdiction is different from magistrate. Of course, the magistrates do not have appellate jurisdiction. Also, the supervisory jurisdiction of the High Court, the magistrates do not have that. Also, the jurisdiction to determine questions of interpretation of the Constitution. The magistrates do not have that jurisdiction. Those are the 3 that I can think of right now.
Justice Majanja.
Yes, good morning and congratulations.
Thank you.
Sorry, congratulations on my part also. I just want to ask you one question. You are aware of Giela versus Casman Brown?
Yes, I am, Commissioner.
And the conditions upon which a court can grant an interlocutory injunction. This case was decided in 1973. More recently, the Court of Appeal has said or decided how these conditions should be applied. Can you tell us what the Court of Appeal has stated?
Thank you, Honorable Commissioner. The Court of Appeal in the case of Nguruman versus Jan Bonde, I forget the name, but in the case of Nguruman, stated that the 3 principles in Giela should be surmounted sequentially, one after another.
And what does that mean in practical terms?
In practical terms, that means it is not enough for an applicant, for instance, to only prove a prima facie case in his case. He must prove a prima facie case. He must prove the second principle of that costs or rather damages will not be sufficient, and he also has to prove that the balance of convenience tilts in his favor.
Okay, and after a plaintiff has proven all those conditions, are there circumstances under which the court will not grant an injunction? Will probably give us examples. You have proved you have a prima facie case, you have proved damages will not be an adequate remedy, and you have proved that the balance of convenience is in favor of the plaintiff. But under what circumstances will you not give an injunction?
In the same authority, the Court of Appeal did give an additional condition. It has just escaped my mind right now.
They may have given, but under what circumstances when you refuse? I'll make it easier for you. Principles of equity.
Yes. If the by application of the principles of equity, it is not proper to grant.
Okay, give me 3 of those.
Where
something about hands.
Yes, it was coming. Honorable. Approaching the court, if a party comes to court with unclean hands,
yes.
If a party is guilty of
delay.
Guilty of delay.
And the last one? Okay, I'll leave with that. Thank you very much.
Thank you.
Thank you very much, Honorable Chair, CJ. Your Honor,
Yes, please.
we also know that you have served the judiciary and the people of Kenya for quite long, and today you are despite the promotion, you are still eligible to be here with us.
Thank you, Honorable.
Now, I have seen your writings before, and we have discussed that before, and I think as a magistrate, chief magistrate now, you are able to write a judgment and so on. As far as you are concerned, in case now you come to the High Court, what will be the difference between your judgment writing presently and in the High Court? What will you be expected how will you be expected to write in terms of the style, the structure, in the High Court compared to what you are doing now? Or are they the same?
Okay, in terms of the structure of it, in terms of the way the layout, the basic layout, it will be the same. But in High Court, sorry.
Yeah.
Okay. Yes, but in High Court now, I will be expected to expound more on the law, because in High Court you are expected to grow the jurisprudence through your writings, and so I will be expected to expound more on the law, give comparative studies from other jurisdictions as I come to my conclusion.
So there will be that difference of the jurisprudential expectation by Kenyans.
Yes.
Interpretation and application of the interpretation of the Constitution.
Yes.
Okay. Now tell me, this is just in passing. It's not important, but in passing. It is common, it has happened, but in your judgments presently, you have spelled your judgment, the word judgment differently in different judgments. Which is the one with an E in between and one with can I refer you to the judgment?
No, I know what you mean. I know what you mean.
Which is the correct one, or which is in Kenya, which is the one that we apply commonly?
I believe in Kenya we should apply maybe the British English, but this happens mostly depending on the machine you're using. Sometimes it is formatted to use US English, sometimes it is formatted to use UK English.
Yeah.
So the difference comes from the type of machine you're using. Okay. But grammatically, both of them are acceptable and pronounced the same way, judgment.
Okay.
Yes.
Yeah. Now, in your judgments, what is the purpose of not disclosing the full names of party in the heading, that now you use initials. What is the purpose? You say JNN or DNN instead of the full names. What is the purpose usually?
Yes, the
common purpose.
Yes, the common purpose is to protect the identity and privacy of the party. Because
what grounds?
Yes, because judgments are for public consumption, and so you do not want to prejudice or expose the party to unnecessary attention.
Will that apply to all parties or only, say, special parties like minors?
Yes, special parties like, yes, minors. But it also applies where in some claims like where someone is suing as a legal representative.
Yeah, that's what. In fact, I was very interested in that. As an example, sample number 3, you say that DNN is the plaintiff suing as the administrator of the estate of DKM, deceased. Yes. What is the reason?
Yes.
They're adults, people die. What is so special? There's another estate.
Most of the time we do that, especially where they are in the estate, there are minors, and probably part of the property will go to the minors. But essentially it's to protect the privacy of a party.
Okay, fine. Now, in the High Court, in case you are appointed, where is the place of a preliminary point of law? How will you deal with it? When it comes, it is pleaded, and there is a matter before you, and the hearing is taking place, or the hearing is starting, the main hearing, and there is a matter of point of law. How will you approach it? And it raises the issues that can lead to the determination of the resolution of the matter, like the issue of jurisdiction. Will you proceed with that issue alone, or continue with hearing everything and then deal with the issue of the PO?
No, procedurally, I should proceed. I should take the preliminary objection on the point of law before, especially when it has the chances are that it will dispose of the suit. I should be able to dispose of the preliminary objection first before engaging the parties now on the suit. Yes.
Are there cases that you have seen courts have done in the High Court or Court of Appeal or even Supreme Court that they have had the matter fully and then taken up the issue of the PO subsequently because maybe there was the issue of time, they were under a rush or the pressure of time, like election petition?
Yes, I was going to say yes, in some claims like the election petition, that would happen. In a claim, in other claims, the position in Lillian S. case is that you should be able to dispose of that preliminary objection before going to the suit.
Okay, thank you very much. I wish you all the best.
Thank you, Honorable Commissioner.
Thank you, Chair. Good morning, Your Honor.
Good morning.
And congratulations also for being appointed as a Chief Magistrate.
Thank you so much.
I don't know whether you remember the questions I asked you last time with regards to your sample writing. Okay, let me refresh
remind
your
me
memory.
kindly.
Making reference to precedents by superior courts. You can now remember that?
Yes.
2 of your sample writings, you've not made reference at all to any decided case of a superior court.
I normally make it a point, Honorable Commissioner, to refer. Sometimes I don't extract a whole paragraph or so to include in my ruling, but I would probably mention it and then paraphrase whatever principle I want to use in that case.
But you have to make reference to that particular decision. You just can't
True.
say you will extract without making reference to the decision.
True.
So the divorce matter, and there was the divorce matter, and okay, for now I can only check the divorce matter. The divorce matter that you sent does not have that. So Superior Court's decisions are precedential, and by virtue of stare decisis, they should be respected. If appointed as a judge, and there is already another court that has determined an issue in a particular manner, how do you upset that particular decision, the precedent set by a judge of equal status in the context of as a judge of the High Court? What would you consider before upsetting a decision of another judge?
I would consider the decision. I would also do a comparative. I would derive other authorities from probably outside the jurisdiction, outside our. Jurisdiction and lay a basis for my decision if I'm going to depart from the holding of my brother or sister.
So why would you be using it to depart from that decision? So what would you an already set precedent?
I do not believe that is enough. You must give a basis.
Thank you.
Yes.
Thank you and all the best. Thank you, Chair.
Thank you, Honorable Chair, and welcome again, Honorable Barbara.
Thank you.
I have only one question, but allow me to also congratulate you on your promotion.
Thank you, Honorable Commissioner.
Now that you want to become a judge, could you explain how the role of the judge today has changed from that of a traditional judge, as we have always known it?
Thank you, Honorable Commissioner. The role of a judge has changed, especially post 2010. And going by our constitution, our constitution emphasizes a lot on social justice. So based on that, and based on deriving from our vision of the judiciary right now, the role of a judge is, besides being an adjudicator of matters in court, the judge must also promote reconciliation. The judge must promote embracing other means of resolving disputes, and so this is it is a big step from where we are before, where the judge was strictly just an adjudicator of disputes.
Good afternoon once again.
Good afternoon, Honorable Commissioner.
I also want to join my colleagues in congratulating you for your promotion to Chief Magistrate.
Thank you, Honorable
I
Commissioner.
believe you're up to the task, even as I also believe you're up to the task to serve as a judge. I have your performance report. We already discussed it with you the last time. I don't want to belabor the point, but your performance report is good.
Thank you.
You are doing quite well at your station, both at the individual level, where your contribution is even above what is expected of you. And I also see that your case clearance rate and your court productivity is higher than the national average. I think this is very good and it's commendable.
Thank you.
I have only one question to ask concerning performance, and I just want to read you a brief quote. It says, performance should be an expectation of employment, and it is the leader's job to create an environment where maximum performance is possible. I'll read it again. Performance should be an expectation of employment. It is the leader's job to create an environment where maximum performance is possible. You seem to be doing quite well at Mavoko. Could you just tell us how you have done this for the people at Mavoko, the staff you work with, and also whether judiciary or the JSC is achieving this in the performance measurement framework that we have? Thank you.
Thank you, Honorable Commissioner. Yes, performance is a legitimate expectation of an employer, and especially where the employer has provided the tools, the proper tools, has provided manpower. It is important that there is output, good output. And so for me as a leader, I believe in building and working with teams. So the first thing I do when I go to a station is to assess the workload, then have a meeting with my colleagues first, and discuss the workload. Then have a meeting with the whole team, which is the staff, and then come up with both short-term and long-term goals. And then I will also have a meeting with my stakeholders and agree on a way forward. So once you've brought everyone on board, it's very easy. It becomes very easy to move as a team and be able to achieve the goals. So like in Mavoko, we were able to sit down, take account of the pending cases, and we agreed as a team to concentrate on the old cases first, giving them priority as we also, continue with the ones that were coming in. And we have been able to do that through teamwork, including the external stakeholders like the lawyers. Yes, we gave them proper notice and told them how we want to proceed with matters. And that is what has enabled us to tackle the workload at Mavoko Law Court.
Support from the judiciary as the employer of the JSC?
Oh, yes. I would say my experience at Mavoko Law Court, the employer has been very supportive. The manpower is, I can say, although according to the organizational review charter, we are, our imposed personnel are, we are at, I think, 60%. We have been able to be, the employer has been able to give us the right cadre of staff that has enabled us to work efficiently. So we do not have, or rather we have been given, let me say, the right cadre of staff that has enabled us to work properly. Yes.
Thank you, my lady.
Thank you, Chair. Yes, Madam, congratulations on being appointed.
Thank you, Honorable Commissioner.
Although you have not taken my suggestion well, you are still saying you are from Siaya only. We are saying Siaya stock Elgeyo Marakwet.
True, I agree with you.
Okay, maybe that is for a later date. For now, I would like you are now going into leadership position, both as a chief magistrate that you are, and possibly if you get that of the judge. And what do you understand by visionary leadership? And where do you place yourself?
Thank you, Honorable Commissioner. The way I understand visionary leadership is a person who is able to give a vision, both short-term and long-term, and put in strategic plans or strategic plans on how to get there, while incorporating input from the team. And I believe that is what I am. I like to have both short-term and long-term plans, and then I tackle the same by having small strategic goals that will enable me to achieve both plans. Yes.
In your leadership position, what are your main achievements?
Okay, as a leader, I can say I am compassionate. I'm also a consummate leader. I'm also amiable, and I'm able to influence those who work with me and under me to embrace my work ethics of professionalism, transparency, and selfless service. I also take initiative in tasks. I remember when I was posted to Baricho Lokot, I was about only 6 months old in the service at the rank of a resident magistrate. And when I got there, I found that men and women, I made it a mission, and I was able to request for funds and put up a women's cell. That women's cell is still in use at Baricho Lokot to date. So I am, in my leadership, I'm able to apply my leadership to make positive impact, both for the internal stakeholder and also the external stakeholders.
Okay, thank you, CJ.
Thank you, Honorable CJ. And Honorable Barbara, I wish to join my colleagues in congratulating you for the promotion.
Thank you.
I will not have many questions for you because you are recently here, and we've continued to see the good work you do in Mavoko. Please keep it up.
Thank you, Honorable Commissioner.
My only question is around the corruption prevalence in Mavoko law courts, and this is based on a report, the latest report that we have, that shows that you're at 7.14 against the average for all magistrate courts, which was at 7.03. Why do you think that is the case? And maybe you could tell us what interventions you've put in place to alleviate this vice of corruption in the station.
Thank you, Honorable Commissioner. While appreciating that corruption is also a matter of perception, I cannot say there could be incidents of actual corruption at the court. What we have done is that we sensitize our clients during salutations, morning salutations. We sensitize them and tell them our services, I mean, all payments to court are paperless or rather cashless. We do not expect them to give money for any service. We also have in place a very robust customer care to give directions to people. And then we also insist that while staff are at work, they must wear badges for identification. We also have in place a talkback box, if the suggestion box, as it is known. So we encourage our clients to give feedback and tell us of any incidences that are there. And then we have a corruption committee made up of staff that discuss any issues that come up and give direction on what should be done and how we can counter whatever incident it is. So it is that is how we are working at it, and I hope in the next survey that figure will be lower. Thank you.
I wish you well. Thank you.
Thank you.
Thank you very much, Honorable Honjo, for that engagement. I think this brings us to the end of the interview. I wish you well.
Thank you.
But we always give a candidate an opportunity to, ask us a question. Yes.
Thank you, Honorable Chair, and I've enjoyed the interaction. Perhaps I have a question. Now that we are moving to web-based online hearing and full-time now, I don't know whether it is in the Commission's plan to put in place policies and perhaps interventions of the screen time, the effects of screen time that the magistrates and judges will have, and how that can be addressed. Because now we will be, on the screen almost 6 hours a day.
Yeah, that's a good feedback on the aspect of awareness on our health as regards the time we spend on the screen. Is that the aspect?
Yes.
Yes, yes. I think that's a good feedback to the Commission, that there is effect on our health when we spend so much time on the screen, when we spend 6 hours on the screen. So I think the Commission will have to interrogate that and see. And I think it's a good feedback.
Okay, thank you.
Yes, yes. Thank you very much, and I wish you all the best. We will get in touch with you when we complete the process, but we encourage you to continue doing the good work you're doing at Mavoko.
Thank you so much, Honorable Chief Justice and Honorable Commissioners. Thank you.